Mr. José Allonca is the managing partner of Allonca law firm in Buenos Aires, Argentina. He's also a founding partner of Allonca law firm, and since 1987, he has been rendering legal advice on business law to foreign and local companies in different sectors and industries, doing business in Argentina and in Latin American countries. José Maria has a large experience in commercial contract negotiations, M&A and cross-border transactions, as well as regulatory issues. He has been part of the academic staff in the Fundacio BankBoston and in the Universidad de la Asociación de Dirigentes de Empresas in matters related to corporate law. José frequently participates as speaker in different seminars related to business law. José also acts as director and syndic in several local and foreign companies representing foreign investors. Saying that, I pass the floor to José Allonca. José, welcome, and please go ahead.
Well, thank you all. Thank you, Carlos, for the opportunity to be with you this afternoon. Thank you, Feng, for having the chance to have this conversation about doing business in LATAM. I do not expect to cover all the issues or the problems or the different aspects that's involved the landing in LATAM, but I decided to to prepare my presentation, including most of the frequent problems that the companies arise when decide to do business in LATAM. So if Charlotte help me, we can move to the first slide where we have the content of this meeting. As a sort of introduction, the idea is to describe LATAM countries saying this is a multicultural experience. On the second part of the presentation, we will discussing some common mistakes or common issues that the companies address and how to solve that. And the third part of the presentation, we will discussing about some investing strategies and their main considerations. And at the end, how to exit the business, what are the problems, again, that the companies usually arise. Can we move to the next slide, please? Oh, okay. So we will refer in this presentation as like countries more focusing on the South American region, because it's my field, my vast experience is doing business in this region. So just to have an idea of what this region means, according to recent IMF estimation regarding the GDP at the PPP, South America is explained by two of the three parts are covered by Brazil. So it is mean that the GDP PPP it's mostly covered by Brazil and Argentina and Mexico. Next slide, please. These are recent projections regarding how how would be the expectation regarding the increase of the GDP by country, and here you can see 2020 forecast and 2022 forecast in the case of Brazil, Mexico, Colombia, and Argentina, Chile, and Peru. I don't want to stop on that, but I leave them just to understand how is the potential evolution of the economy in the South American region. Can we move to the next, please? What is important, and we try to stress is where are the potential opportunities to optimize the legal resources, the legal business resources in the region. And it's important to consider for those that don't know that there are two main free trade agreements in South America. One is the Mercosur, which involves free trade zone where it's part Brazil, Argentina, Paraguay, and Uruguay as founder members, and also they have associated countries like Chile, Peru, and Colombia. Again, Brazil is explaining most of the figures that you can find in this chart regarding the population. Brazil is currently about 200 million people, and the total Mercosur is about 300 million people. So what is again the size of the Brazilian market is critical and important in order to consider doing business in LATAM. On the right part of the slide, you can see the Comunidad Andina, the Andean Community Treaty, which involves Bolivia, Peru, Ecuador, and Colombia. This treaty, in the same way that the Mercosur, allows to do business within the countries without paying any import taxes. In the case of the Mercosur, if the products are they try to sell from one country to other, has at least 60% of the local content, the exportation of those products will not pay any importation taxes. So it is critical and important in order to have a strategy to do business with the Mercosur countries. And also, as I said, Mercosur has different specific agreements with Peru, Chile, Colombia, and also with Mexico as well, where you have different kinds of level of tariff that most of the times are close to zero. So it is important to understand indeed how could be this operate in the case of the company decides to start doing business in the region, how to planify the production, how to planify the activities considering these benefits. It's important in case of the Andean community that in case of the exportation of services, there is an interesting tool that the treaty has, where it means there's no withholding taxes on the payment from one country to another. So for some tax planning, if you decide to open a services company in Peru, for instance, you can export from the different countries of the Comunidad Andina without suffering any withholding tax. Please, the next slide. What is important also to consider for the companies in order to planify or their business and also to do an exhaustive tax planning is that most of the country has an extensive network of treaties to avoid double taxation. So, Argentina probably and Brazil has the largest list of treaties to avoid double taxation. Most of the well-developed European economies has also treaties to avoid double taxation when the main South American countries. So it is most of the time in terms of the when the company decides to do business in the South American region, decide whether it would be located the holding company. What is very common, we work a lot on that by establishing the holding company in countries like Spain or in Netherlands, because of those countries, and the UK as well, because those countries has a large network of treaties to avoid double taxation within the whole South America. What is also important to consider that Colombia, Chile, and also Peru has a large bilateral treaty agreement where, as you can see in the slide, Colombia has a treaty bilateral treaties with the EFTA, with Mexico, with USA as well, Peru and Chile, which also has a treaty with the European Union. Unfortunately, Mercosur is still negotiating the bilateral treaty with the European Union, which is it was expected to have a final conclusion by the end of this 2021, but unfortunately, and due to political situation, these negotiations are concluded, but the final part is still in fact on hold. So, but I mentioned this free trade agreement that Colombia, Chile, and Peru have in place because it's also interesting to consider those countries as platform to export, to leverage with those treaties, and not also to sell to US, but also to sell to Asian countries. And that's why we have some clients, we already do that, establishing a sort of exportation platform to Asia from Peru. Next slide, please. What we will talking in the next minutes about from our experience, what are some of the common mistakes the companies does in South America. In general, we've been advising companies that unfortunately don't do a comprehensive country due diligence. When I said country due diligence, it is not only tax and legal, but also how each country do business. What are the main issues to address country by country? Because again, as I said in the beginning, besides all looks like the same, South America is a really multicultural country. This is not the same to do business with an Andean country than Argentina or with Brazil. So it is important also considering the size of the different countries, the evolution of the maturity of the business depends on the vertical of your company try to develop the business in the country. So it is important. I think it's absolutely preliminary to understand where the company is going and how to start understanding the local culture. And unfortunately, as I said, we have different multinational clients decide to do business in our region. But what I said, it's most of the time it's not at the permanent establishment by opening a company, but just at least to sell products, to appoint a distributor or an agent, but not considering or thinking just that the things are similar in Europe and the US, but it's really different. So this comes with the, as I said here, the underestimation of the local knowledge, and try to pretend impose models, foreign models. It not works. Most of the times this don't works. Also, it's sometimes happen because of we will not spend a lot of time in this country. We will delegate in someone we met, and we I think we rely on them. It's a distributor or again an agent, someone who and let them to do all the things to deal with all the issues. It is not work. It's not work. Unfortunately, and although the market size sometimes is not relevant, it is important to have an involvement in order to avoid further problems. What we also have in South America, unfortunately, and at this moment, especially in my country, in Argentina, is the stories repeats. Although most of the country don't have an inflation, unfortunately, Argentina has right now a high inflation, and also is again suffering foreign exchange controls and trade restrictions. So it is not easy sometimes for the companies to deal with that. And also maybe, as I said, there's always opportunities also in the worst country scenarios. So and although all the current problems in the case of our country in Argentina, there are some companies coming here to do business. So but they should consider what is the inflation, where the extension of the variety of the FX controls, and also the problem with the trade restrictions. So and again, it is also right now there are some question marks on what is going to happen in some countries in South America as well. Where we have currently a new government in Peru, what is highly criticized for most of the sectors, and they already have 2 or 3. I think yesterday was they changed the foreign affairs minister, and also the candidate that the new government has for the economy minister. They do not accept the position. So we will have also some problems in Colombia, and also I suspect to have a new constitution in Chile as well. So what I say is there are times of changing in probably in the whole South America. So I think some past and no well some past formulas of doing populism would come back. So what is important to be prepared on that. What we also have in South America, there is a high level of formalities and bureaucracy, although some countries like Brazil are doing their homework very well in terms of speed up the formation of companies, regulations, also facilitation of participating of the companies on international bids. We are looking at very recently that some changes were introduced by the Brazilian government. So, but again, the formalities sometimes that are a problem or are a barrier for the companies to start doing the business, and it's important to understand that at the end of the day to have a very well prepared timeline and in order to know how long take the formation of a company, the opening of a bank account, I don't know, all of the different steps that the company should have in order to start the business in the country. The last but not least, labor law issues, especially in countries like Argentina, and maybe less in Brazil, but it's sometimes a barrier. It could be a break. A problematic issue. Please, the next slide. A problem that you as CFO probably suffer from time to time is the reporting, especially from if you have your counterpart in the country that they don't deal with the reporting on to a counterpart in outside of the country on regular basis. So it is important from our experience to establish from scratch a structure of reporting. How do you want to receive the information? How do you want to be with if you want to receive on weekly basis, on monthly basis, and because it's sometimes a waste of time and money, and sometimes it complicated the day-to-day. So and the problem is most of the cases it's a business that do not justify the spending the money and the time that spent in these kinds of problems. So again, accounting and reporting is a critical issue. Sometimes what happens is, from our experience, the client decide to hire a firm, accounting local firm, or accounting or legal firm with what was recommended sometimes for the local counterpart, but those firms don't have too much practice with international clients. At the end of the day, it's again a waste of money and time, and as our recommendation is, if you go to the country, whatever South American country it is, it's try to find the firms that they have international clients with the recognition, and it not means that you have to go to the big fours or big 10 for doing that. Right, in each of the South American countries, there are medium-sized firms, accounting, legal, and that can deal with that. And what's the point is to find that. That's it. We've been discussing a little bit about that, but again, tax and legal planning is critical. and specifically in countries that is not easy to understand the tax regime, like I said, probably you can find it within the whole South American countries, except Brazil, a common tax structure, which is VAT and income tax. But in Brazil, what do you have? You have three different right now. The tax system is under a deep reform, but you have three regimes in Brazil. Two of them are applicable for foreign investors. That is one regime you pay on the presumed income, and the other you pay on directly on the income, as in the other different regimes around the world. So. But in case of BIT, there's no specific BIT, and in Brazil there's what is it's tax name ICMS, what is from state to state. It's not a federal tax. What is in the other countries is always federal. So it have different rates. It depends on the state you are doing business, and also services are taxed by the municipalities. It's not taxes on the municipality level. So it's highly complicated if you don't have a deep tax planning, and also probably you should have to not just one, but you should have a second opinion regarding the taxation of your business, which is important, really important, because there are a lot of discussions on also on the judicial level, whether it's a company should pay a tax or not, what is the rate or not. And but again, the point is to understand that it's really problematic and complicated. It's probably your tax advisors at your firm will not at your company will not understand. They will never understand how the taxes works. But this is not a question to try to understand. It's a question to have the opinion, to analyze the business before incorporating a company, before I start doing the business. It's critical, and it's important as any other country in the world. Also, what happens, and also I'm going to refer to Brazil, is Brazil is probably it's a country which has different countries within it, because it's not the same if you are doing business in the south. If it's not the same if you're doing business probably in the central region, which is Sao Paulo, Minas Gerais, Rio de Janeiro, and it is not the same probably if you will do business in the northeast part of the country. It is again, I am speaking about own experience of doing business, of helping companies do business in Brazil. That it's critical and important to although you can have your firm in Sao Paulo, but if you are going to do business in Ceará, you should need a local lawyer, a local accounting firm to explain, to understand how the things going there. This is, although it's probably most of the it is the same law, but the interpretation and the understanding and the local relationship are critical. So it's a very important point to consider, mainly in Brazil. The other point that sometimes is problematic is the protection of the IP. by means trademark, by means intellectual property, by means patents in general. Don't let those registers in hands of your counterpart in any of the countries, because it's important that the company do by themselves. Sometimes if you are in the, I don't know, in the medicine or in the healthcare or in industry, where there are specific registrations that requires that you have a laboratory, you have some facilities, you have a local agent. Do not forget to have an agreement where you can cover that the proprietorship, the ownership of the registers are in hand of your company. We saw some conflicts again. Sometimes it's a problem with the decision to start selling products in X region and appoint a distributor is sometimes something that is taken from one day to another, or so because of some introduction what someone do, and say, well, let's start the business there, and but if you don't protect, if you don't have an agreement in place, if you don't protect your intellectual property and you let in the hands of the counterpart, because of sometimes it's highly cost to register a trademark, highly cost to register an intellectual property, you can suffer further problems. Could you move to the next, please? Well, what could be the strategies we will regularly see with clients doing business in South America? In terms of exportation or selling of products, also services, but mainly products, agent and distribution agreements, although they are under common standards, although all the laws, all the South American countries' laws allows you to the choice of law and jurisdiction. That means that you can choose the Spanish law and the Court of Barcelona to discuss any problem that may arise with the country, any breach of contract or whatever will happen. It's important that consider or to do a deep analysis of how the local law, how the local law understands the distribution agreement, the agency agreement. In case of Argentina, we recently were enacted on 2015, were enacted a new law regarding agency and distribution agreements. Brazil has a large and strong agency law which protect the agent and which is important to be considered, and countries like Colombia and also I think and some Central American countries have different laws regarding that. So it's important how they work. If it's and not always if your choice of law and jurisdiction in your own country would really protect you. So it's important to take a look on that. Depends on each case is a particular case. So, but again, I would say it's choice of law jurisdiction. It's possible to protect you as beside your own country, but please consider how those kinds of agreements works in each South American country. Incorporation issues, as I refer, I think the main point to consider is the jurisdiction of the holding company of the business. If you decide to incorporate, where you will locate, if you have a holding company or not, if you have choices to different companies that are part of the chart of your company again, you can choose by leverage of the treaties to avoid double taxation, by some other treaties. We see that it's a sometimes you can find or take advantage of those legal tools. Because again, if the repatriation of benefits, the payment of royalties or services, intercompany services, wherever you will be the flow between the subsidiary and the headquarter, it is sometimes you can gain some benefits or reduction of the withholding tax rates from the South American country to the headquarters. There's no specific requirement in any of the South American countries regarding to foreign investors. The company should be owned by 100% by foreign investors. There's no longer requirement in Brazil, as it used to be, but 20 years ago, that they have a local shareholder or partner or member from the company. And in every South American country, the company should be owned 100% by the foreign investors. It's not. It means that it's a local company. It's a Brazilian company. It's a Chilean company. It's a Colombian company, but owned 100% by foreign investors. Every South American country also have the different business forms to limit the liability of the members. That's why sometimes. The point is, sometimes the question is whether to choose a branch or a subsidiary. The point is, we always prefer to incorporate a subsidiary instead of the branch, because the branch you don't put any barrier between the liabilities in the South American countries from the headquarters. So you can suffer if you have some liability in, I don't know, in Argentina, for instance. If you have a branch, the headquarters would be liable on that liability. That's why. But sometimes happens that we don't have any chance to then incorporate the branch because of some requirements, and sometimes in international bids and constructions and engineering. And it's happened recently for us that we should incorporate a branch instead of a subsidiary in certain South American country. In terms of a resident requirement, as I said, there's no specific or mandatory rule in any of the South American countries regarding the ownership, but some countries require, just in case that, for instance, Brazil requires that the legal representative of the company and also it should be a Brazilian resident, and also the foreign shareholder or member or whatever should have a power of an attorney which represents the foreign investors. That's why, in case you will need a local resident. There are some agreements at Mercosur level in order to obtain the residence, which is sometimes a tool. If you have a company in Argentina and you decide to open a business in Brazil, but you don't have any Brazilian resident to nominate as a legal representative, some of the Argentinians members of the company can get the temporary residence and cover those positions. It's important if you decide to appoint a third party not related to the company to establish a restrict and limit all the powers in order to avoid any further problems. What is interesting also that if you would have a local partners or local shareholders in the company, sometimes to be a partnership, or sometimes you should enter into a joint venture that you have two or more partners. Always it's very advisable to enter into a shareholder agreement in order to get the things clear on the first step, and then also to enforceability of the decisions. In case of Brazil, for instance, because it's not the same in Argentina, the shareholder agreements are duly enforceable. Regarding to incorporation timing and cost, this again is as I said, you should when you decide to start the business in any of the South American countries, this is very advisable to request to the advisors to establish a timeline in order to know how long it would take the incorporation, how long would take the open of bank account, and also the cost. And it is important that if you are pitching some companies and some firms, and you have a very well detailed proposal, because sometimes I had a high cost within those proposals. So it is important to take care of that. The other alternative it could be to enter in an M&A or acquisition of existing business. Sometimes it happens, it's very common. We participate in many of them to acquire the distributor or some specific assets that of the distributor of I don't know, clients, or not a specific acquiring participation on the shares of or part of interest in a company. Okay. In any case, or in any kind of M&A, what is critical to proceed with a preliminary and then in deep due diligence, because of as I said, if you are acquired a business that are family owned, which is very common in South America, you can find a lot of informalities. We sometimes we've been advising different investors in South America, and recently in some that they target I don't know, a couple of advertising companies which do business within the South American countries, but those target company looks very pretty, very interesting with preliminary very interesting EBITDA and etc. But when we go deep to the papers, we understand that the business could be very good for the current shareholder, but for being acquired, those companies have a lot of liabilities because of the way they do business, the way they try to optimize the payment of taxes, and also with a high level of labor law risks, because as I said, labor in South American countries in general could generate a high kind of liability, because sometimes the employees are not hired like employees on the payroll. Sometimes they are hired as independent contractors, and there is a very wide interpretation of the South American court regarding whether they consider any kind of independent contractor which regularly work for a company, or not irregularly but work from time to time for a company, which should be considered an employee. So this is a critical issue, and also in terms of outsourcing the business in general is a critical issue. And as I said, family business own company that maybe could be a target of your companies, you should take a look, a very deep look on the documents and do a comprehensive due diligence. Please, the next. Well, I think we have just 5 minutes. Just for concluding, on general, to exit or conclude a business close a business in South America is not easy as could be in US or in Europe. Exit the business, you can exit like the sale of assets, a sale of in general terms, part of the assets, or sell sell your participations, your shares at a stock purchase agreement or similar kind of agreement. But sometimes what happens if the business don't works and you have to close the business and you don't find anyone who can buy the business. So you should enter. You should enter if you are in an insolvency process. You can enter a reorganization process or a bankruptcy process. Those process, again, no matter the country you take a look how that the proceeds. There are large judicial proceeds, involves a lot of cost, involves a lot of third parties, involves the government as the tax at different levels, trying to do audits, or it's quite complicated, and also depends on how the thing will work. If there could be some kind level of liability of the main shareholder, there are cases where in general terms the shareholder will be liable for all of the liabilities of the company. So in those kinds of processes, so it is important this is not a for doing an example. This is not any kind of Chapter 11 process in South America. There are large, problematic, involve a lot of cost for the company, and although there are very well succeed reorganization process from some large companies, but in most of the cases, this is not the common rule. If you go to a dissolution and liquidation of the company, winding up of the company, again, you should think in 1 or 2 years process. No matter the country, you will do that. So again, it's sometimes problematic, and also because of you can suffer the audits of the tax authorities and different bodies that they try to collect or question it that you are closing and you don't pay. So at the end of the day, what we sometimes do is to put the company in dorm, try to liquidate the assets, try to deal to manage the different problems that the company should have, and put the company dormant. At the end of the day, went for the period of the statute of limitation of the tax claims, and after that, if there's no any claim, so on taxes, or most of the time these are the more problematic issue. We decide to liquidate, but again, it should take the time of the wait for the status of limitation of the relevant claims. So for my part, I think those were the things that I tried to comment to you guys, and in order to explain a little bit what is on real cases, the problem that we have, and sometimes how to solve or not. And I open for any questions you may have. If not, please feel free to contact through Carlos Dibrico any question you may have.
Okay, thank you, Jose. Any questions, comments?
Yeah. Hey, Carlos. Can you hear me?
Yes, Juan Carlos.
Yes. Hey, I would like to say thank you very much for the presentation, and really enjoy to have this additional insight from Jose. I have a question regarding the current situation in Argentina. Jose, how do you see the currency controls? What is your expectation about the flows, about the US dollars within Argentina? What is the new regulations that you can see in order to expedite that, and for the multinational companies, which probably are very concerned about the regulation and the exchange controls?
Unfortunately, we will have FX control rules, not decreasing, increasing probably. So the government is trying to restrict. The government don't have dollars, okay? So they try to restrict any kind of payments, any kind of alternatives to get dollars, okay? So the FX rules came back on September 2019, and from them up to now, there was the restrictions were increasing. So we don't have too much loopholes. Mainly, the main problem is to pay back loans and also services to within the subsidiary and headquarters level. But it's if the regulations identify some kind of relation between both parties, the restrictions are strong, and in one cases they request to the previous approval of the central bank. That's why we have many problems. It happened. Imagine flows within intercompany flows, and not only with loans, but also with the company that distribute products from here in Argentina. They had to pay the invoices, but it is very common that the invoices will not be paid for an X period of time. And it happened right now. What is if invoices? If you have unpaid invoices from the 2019 September and less, the central bank do not approve. If you are a related party, they don't approve also. That's why some of the companies are going to the court to ask, well, I need to pay.
Wow.
I have three claims right now. We represent the three, in this case, three Brazilian companies. They have a large amount to receiving unpaid invoices in Argentina from 2018 and 19. And the client here in Argentina agrees to pay, but the banks don't want to pay, don't accept to pay. But the problem is, the central bank is putting a lot of pressure on the banks, and not always there are written rules about that. So the problem is, each bank and the COMEX department bank has a permanent inspection audit of the central bank. So the pressure that the banks are receiving, when I say large bank like Santander, like HSBC, each bank of the system has received a lot of pressure. So it is really complicated to deal with that. Imagine also, and on the other side, you have the exporters that it's mandatory for the exporter to liquidate within the X market. Within all the receivables. So as soon as they receive the payment, they should liquidate. And the bank is the central bank is tracking that. The central bank is putting a lot of pressure on the banks to follow up that as well. And I know it is related to product, but also with services as well. So that's why we are doing different kind of alternatives, purchasing bonds, Argentinians in US, and sending the bonds, and different kinds of. The companies are receiving loans in kind, not in currency, because imagine if you have to make a capital increase. This is from today, a problem that I have today, early today. A company should do a 1.5 million capital increase. If they make this capital increase in pesos, they will receive, help me, Carlos, 1 million in pesos. How much is pesos? How much millions pesos? $1 million is
divided 100.
100 million pesos. If you do the same in kind instead of in currency, if you do in Argentinian bonds or ADRs of Argentinian companies or etc., you can receive 180 million pesos. That's why.
Wow.
Imagine you as CFOs all around the world try to explain that how it's worked.
Right.
CFO. It's impossible. It's really
yes, and this is because you see we have a different multiple exchange rates in Argentina. So we have the official rate, and then we have I would say a black market. Official rate is around 100 pesos per dollar. Then we have the black market, I mean, is 180. I mean, you see 80% plus. Then you have this, as Jose mentioned before, this exchange rate basically because of bonds transaction. And this is for about 170. So, and then we have, you see, for example, in my case, when I bill to a company, a foreign company, you see, let's say Europe or US, you see, I don't receive the dollar they send to me. The dollars, you see, are kept by the central bank, and my bank, you see, pay me in pesos, but at the official exchange rate. So I mean, I'm losing 80 pesos per dollar, because they pay me 100 pesos per dollar, where if I go to the market, I had to pay 180. You see, this is sometimes it's difficult for us, you see, to understand this. It's a mess.
Yeah.
a mess.
No,
You see,
but
imagine it
but
at a
also
corporate level.
but also there are not also restrictions on I mean,
The dividends payment.
foreign exchange market. There also you have also restriction with it. You should have a large list of products that you should need a prior approval of the government to import. This is the second or the first level of importation. We represent here in Argentina a large tires producer that they don't have local production, but they import. And they import, I mean, the very high level cars tires, and also for trucks. And there's no any competitor in Argentina. There is that can compete with that company. But in any case, they restrict. They have quotas, specific quotas, and in the past, that company only could import with the judicial authorizations. They went to the court and asked to a judge, well, give me the authorization to import because I fulfill all the requirements. I wait the 30 days. I do all my homework, but the government do not approve. So this is very complicated, really complicated. It's very sad to be speaking this kind of things today, but it is what is happening in Argentina. Guys, in this sense, through Carlos, any help you may need here, please feel free to contact us or I don't know, any question you may have, please, absolutely.
Yeah, but if you have experience dealing with this kind of issues in Argentina, that will be very well received. You have your support and advice about it. So I will in touch with Carlos in order to get that contact information. I know that we have already in the presentation, but I would like to have an additional insight about it, especially for the business that the company does in Argentina. So glad to know. Thank you very much, Jose, for your very well response.
I don't know if sorry, maybe I didn't. I realized that they have a lot of very well respected professional working on in South America, or at least with a large experience in South America. So I feel a little shine of that, but I try to did that with
no
general
worries.
perspective, and the idea is to know that there are a lot of opportunities here. So they try to.
Life is a never-ending process, you see, for learning.
Mm-hmm.
Yeah. No.
It's a journey for sure. I have a question for you, Jose.
Absolutely.
One of the large difficulties I have seen in the past in Brazil and in Argentina and to somewhat Colombia, Chile, and Venezuela, I'm not even going to go there, is conflict resolution. You have a shareholders agreement, or you have a purchase agreement, and then you have to agree on where to resolve any difficulties, and sometimes it's the Canadian chamber, and everybody wants either, if it's a U.S. company, they want the state where they are, or in London or whatever, and obviously the locals always want the little town outside Sao Paulo with 1,000 population, where the judge will give him a very favorable sentence.
Yeah.
So how is that evolving? I can honestly say in the situation that I have seen in Brazil, in Argentina, when we bring in investors from outside, and then something goes wrong, especially with the financial crisis back in 2008, it was a total mess,
Yeah, I know.
Fees of lawyers in London, fees of lawyers in New York, Sometimes they were mind-boggling with different legislation, and of course, we will never get to any place. We will have to basically take a hit and leave the country. Yeah. How is that evolving in the last years?
Well, let me tell you, there are 2 points. Maybe, as I said, I try to explain very briefly. When a major agency and distribution agreements, choice of law, etc. By means, you can also choice of law jurisdiction. You can choose an arbitration, and you can say, well, I can choose the ICC, and I go to France and discuss there. But the problem is, after you have your decision by the arbitration or mediation or whatever kind of alternative dispute resolution process you decide, and it takes obviously money and time, but seeing that you have I don't know, 6 or 8 months or 1 year of an arbitration, and you won, you have a final decision. You have to go to do the exequatur, to validate the decision in the country. If
That's
you
right.
go to Brazil, you have to go to the Supreme Court. Then the Supreme Court can analyze. In case of Brazil, they have the power to analyze, to discuss whether the decision is complied to the Brazilian law or not. It will follow all the procedures, but it take in the best scenario, it could take 6 or 8 months. But recently I have a case which involved a French company, a large French company. They contact us to say, well, we are with one of the top 5 Brazilian law firms, and we get our court decision 1.5 years ago. We don't have any news about that. What is happening? So what happened there? There was with a small the defendant found a small piece of arguments for discussing. They get a 1 year also, 1.5 years discussing that. Although the decision. What is important if you go to an arbitration is if the defendant is basically domiciled in Argentina or in Brazil or wherever country, what could be the next step? What point we should take care of in the arbitration in order to avoid further delays in the respective country of the execution of the decision. But what happened in that case, that the investment fund or VC, venture capital, appears to say, well, I will purchase your credit, and the credit was sold at the 50% of the value because of the French guys. Yeah, but
these are problems that will be going on for decades, and you're absolutely right. Then at the end of the day, you have to enforce it here in Brazil or wherever. We had a similar case. The last one that I had cross-border was in Argentina, where the Brazilian company was held liable because Coca-Cola did not get its sugar through a sugarcane mill that the Brazilian was supplying the boiler. So it took like 10 years for it to come about. And by that time, the sugar mill had gone out of business.
No matter,
but have you seen, my real question is, have you seen progress in that in the last 5 years or so? Or are we still where we were 10, 15 years ago? Is it moving to some kind of a better direction?
There are two points. In general terms, all the alternative dispute resolution methods will increase, become very, very common, okay, in general terms. So there's more professionalization, there are more techniques, all the professionals involved in arbitration you have teams of arbitration in any part of the world that they work, deal. This is not a, that in one point or another, these sorts of things have been speeding up the process. But the point is, again, there is a barrier when the decision arrives to the court, the local court or the inferior courts in case of Argentina, and to discuss the constitutionality of the decision, if it's constitutionality or not, if it complies to the local, because the point is, if the decision should comply in general terms with the local procedure rules. So that's why this is sometimes a discussion. But I think that, again, and there are more and more, not only on the large ADR bodies like the ICC or AAA in US, but as you said, chambers of commerce, they are very common right now to discuss that's why also, as I said, it's important sometimes, depends on the amounts involved, the importance of the agreement, or etc. Sometimes to accept the local courts or at least a local alternative dispute resolution. For instance, in Brazil, we've been working with the AmCham from time to time in Sao Paulo very well, and also I think the Canadian as well. But again, the important is to try to work before and not go to the court. But sometimes it's not possible to avoid a court or to put in a discussion. No, just but
so if I understood what you said, if I can sum it up, is like the process itself, the technical part with consultants, with evaluations, with lawyers, that has kind of speeded up in the last few years. But when it gets to the court system, it's still where it was forever.
Yeah.
Okay, gotcha.
Yeah.
Thank you.
No matter if you go to the largest law firms also.
No, I know that.
In this case, in that case with the French guys, it was horrible what one of the 5th large law firms in Brazil did, because they spent almost 6 months discussing their own fees, whether if they should receive their fees or not. It's a technical issue, but imagine the French guys, whether the French don't have too much patience with all. So when they realize that, but it's another part of the story. But again,
yes, especially tax lawyers, I would say.
Yeah.
Okay, very good. Thank you, and it was a great presentation considering how big the topic is.
Well, thank you.
Into 9-10 slides. Yeah.
Thank you. By the way, you are living in Brazil.
That's right. I live in Brazil. Yeah. In Sao Paulo.
Where do you live? In Sao Paulo. Okay. Well,
in Sao Paulo, yes. Yeah.
I've been to Brazil at least, I don't know, 6 times a year per year, but since the 2019 December, I couldn't come back.
Yeah.
So, well, great.
Great to meet you. Okay.
Well, no more questions, no more comments, so we can end up here the meeting. And thank you, Jose, again, and thank you everyone for attending.